Good morning to all. Myself, Professor T. M. Devakar, working as Assistant Professor in ENTC Department in Sharad Institute of Technology, College of Engineering. So, today we are going to study about the human rights at international relationship. So, what exactly is the meaning of the human rights? In the previous videos, we studied about the human rights, the meaning of human rights, but at the international relationship, the meaning of human rights is different. So, human beings are rational beings, and they, by virtue of their being human, possesses certain basics and inalienable rights which are commonly known as the human rights. So, the human rights are defined as all those rights which are essential for the protections, which are essential for the maintenance of dignity of individuals and creates conditions in which every human being can develop his personality to the fullest extent, which may be termed as human rights. So, the human rights became operative with the birth of an individual. The human rights, being the birthrights, are inherent in all the individual irrespective of their caste, religions, sex and nationality, and because of their immense significance to the human being, the human rights are also sometimes referred to as fundamental rights, basic rights, inherent rights, natural rights and birthrights. So, there are different meanings of the human rights as we seen. The World Conference on Human Rights held in 1993 in Vienna, which stated in the declaration that all human rights derived from the dignity and worth inherent in the human persons, and that the human person is the central subject of human rights and the fundamental rights. Next one, the introduction of the human rights in international relationship. That is, even though the origin of human rights is ancient, the international concern with human rights may be said to be the comparatively recent origins. So, the United Nations Charter, which marks the advent of systematic human rights protections within the international systems. So, the idea of human rights is as old as humanity. Its systematic proclamations and declarations are more recent. The world's first Bill of Human Rights was discovered on the clay tablet, which is dating back from the region of Cyrus the Great, that is, which is code is 555 BC. The documents which form the historical foundation of modern human rights are the English Bill of Rights, that is 1688, the American Declaration of Independence, that is 1776, and the French Declaration of Rights of Man, that is in 1789. The legal process in the universality of human rights effectively commenced with the Universal Declaration of the Human Rights, that is the UDHR, in 1948. So, what exactly the modern human rights? So, the human right is one of the such rights which has been confirmed to the individuals by the state in the modern international law. The modern perspective to human rights is reflected in the Vienna Declaration, which is adopted by the World's Conference on Human Rights in June 1993. The declaration categorically states that all human rights are universal, indivisible, and interdependent and interrelated and democracy. The development and respect for human rights and fundamental freedoms are interdependent and mutually enforcing. The conferences reaffirmed the right to the development as a universal inalienable rights and an integral part of the fundamental human rights. So, next one, the legal process in the universality of human rights effectively commenced with the Universal Declaration of Human Rights in 1948. The adoptions of the United Nations Charter in the aftermath of the Second World War can rightly be confirmed as a landmark in the journey which towards the universal acceptance of the human rights. Through a long process of evolution, the modern human rights jurisprudence has crystallized into three basic principles. Number one, the principle of universal inherence. Second one, the principle of inalienability. Third one is the rule of law. The first one, the principle of universal inherence, that is, every human being which has certain rights and he has a capable of being implemented and enumerated and defined, which are not conferred on him by any ruler, non earned or acquired by purchase, but which inhere in him by virtue of his humanity alone. Second one, the principle of inalienability, that is, no human being can be deprived of any of those rights by the act of any ruler or even by his own act, or in democracy even by the will of majority of the sovereign peoples. Next one, third one is the rule of law, where the rights conflict with each other. The conflicts must be resolved by the consistent, independent and impartial application of just laws in accordance with the just procedure. An individual can seek human rights only in an organized community, that is, the state, or in other words, where the civil social order exists. Thus, the principle of protections of human rights is derived from the concept of man as a person and his relationship with an organized society and which cannot be separated from the universal human natures. So, the human rights being essential for all round development of the personality of the individuals in the society and be necessarily protected and be made available to all the individuals. So, they must be preserved, cherished and defended if peace and prosperity are to be achieved. So, the human rights are the very essence of meaningful life, and to maintain the human dignity is the ultimate purpose of the government. So, what are the kinds of the human rights? The nature of both civil and political rights, which may be different, but they are interrelated and therefore it does not appear logically to differentiate them. So, this reason which leads to the formulation of one covenant covering both civil and political rights into one covenant, that is the International Covenant on Civil and Political Rights. The economic, social, cultural rights, that is economical, social and cultural rights are based fundamentally on the concept of social equality, which is also called as a freedom too, are related to the guarantee of minimum necessities of the life to the human being. So, in the absence of these rights, the existence of human being is like to be an endangered. So, the right to adequate food, clothing, housing and adequate standards of living and freedom from hunger, rights to work, rights to social security, rights to physical and mental health and rights to educations are included in this category of the rights. So, these rights, sometimes called positive rights, which acquires the active interventions, not abstentions of the part of the states. So, the enjoyments of these rights requires the major commitment of the resources, and therefore their realizations cannot be immediate as in the sense of civil and political rights. Although the United Nations has recognized the above two sets of rights in two separate covenant, that is International Covenant on Civil and Political Rights, that is ICCPR, and International Covenant on Economical, Social and Cultural Rights, that is ICESCR. So, there is a close relation between them, and it has been rightly released especially by the developing countries that civil and political rights can have no meanings unless they are accompanied by the social, economic and cultural rights. Thus, both categories of rights are equally important, and where civil is and the political rights do not exist. So, they cannot be full realization of the economic, social and cultural rights and vice versa. So, what are the international human rights law? So, international human rights laws has been developing extensively since the creation of the United Nations. The most fundamental point about the human rights law is that it establishes a set of rules for all of the peoples of all the states. So, human rights is the international in the sense of it being universal, which applying to all the individuals. However, international human rights laws refers mainly to the obligation to the obligation of the states to the individuals within their jurisdictions. When states fails to assure a realization of human rights to the individuals within their jurisdictions, international obligation arises. Thus, obligations to provide human rights individuals is mainly intranational and in some cases international. So, thus the state is not free to treat its nationals as it pleases despite the fact that it is sovereign. Because the sovereignty, as we studied in the previous videos, the greatest impact of human rights laws has been to erode the absolute control which states had in the classical period. The efforts for the creation of the international organizations in order to establish peace were being made even when the World War II was in progress. Many declarations adopted by the conferences laid down the importance of the human rights. The Declaration of the United Nations, signed on the January 1, 1942 at Washington, and was the first documents which used the term human rights. Thus, the human rights became a matter of international concern with the end of World War II and the founding of the United Nations. Since then, international human rights laws has been developing in an unprecedented way and has become a very substantive part of international law as a whole. Although there is no global government as such to protect human rights, it is being protected by the various bodies of the United Nations and the governmental organizations. So, what are the promotions and protections of the human rights by the United Nations? So, the prime responsibility of the promotions of the human right under the United Nations Charter rests in the General Assembly, in economic and the social counseling and its subsidiary body, that is the counseling of human rights. The term protection of the human rights, which may mean implementation and enforcement actions, does not find place in the United Nations Charter. When human rights violations assumes massive dimensions, the General Assembly and other organs of the United Nations can initiate discussions and actions. Among the United Nations agencies, only the Security Council and the International Court of Justice can engage in enforcement actions. Only they have a competence to pass a binding resolutions or issue a binding judgments. Enforcement is thus the authoritatively applications of the human rights. The United Nations in the past has been able to promote and protect the human rights by certain way, which are as follow. Number 1, the human rights consciousness, that is the first and the most important role which the United Nations has played is that it has made the people and states conscious about the human rights and the fundamental freedoms. Second one is the codifications of the law of the human rights, that is the United Nations has codified the different rights and freedoms by making the treaties for all sections of the people, such as women, childs, workers, refugees, etc. The Counseling on Human